If you're a U.S. green card holder living in America right now, you need to listen very carefully, because what I'm about to explain could either protect your future in this country or quietly put it in serious danger. This is U.S. citizenship and visa, and today I'm breaking down a brand new immigration rule that has just gone into effect with real enforcement behind it. No hype, no filler, no wasted words. Just what actually changed, who it impacts, and what you need to start doing right now. For a long time, many green card holders have operated in a kind of gray zone. On paper, they are permanent residents of the United States, but in reality, most of their everyday life is outside the country. They fly in once or twice a year, stay for a few weeks, keep a U.S. mailing address or a bank account, but their real home, family, and work are overseas.
Legally, permanent residence has always meant that your primary home is supposed to be in the U.S. But in practice, enforcement of that idea has been inconsistent. That inconsistency is exactly what this new rule is designed to shut down. The government has now put in place a formal system that tightens what it means to maintain your green card, uses new technology to track travel patterns, and adds new reporting requirements that every single permanent resident will have to follow. I'm going to walk you through all of this in detail so that, by the end, you'll know if you're clearly safe, clearly at risk, or somewhere in the danger zone without realizing it. Under the old, practical approach, many people assumed that as long as no single trip outside the U.S. was longer than 1 year, they were basically okay. Some people pushed that to the limit. Some filed for re-entry permits, and a lot depended on which officer they happened to meet at the airport.
The new rule changes that in 3 major ways.
It lowers the concern threshold to 6 months. It looks at your overall pattern of time in and out of the country over several years. And it adds a structured review of your ties to the United States, not just a raw count of days abroad. Let's start with the 6-month piece. Under this regulation, any single trip outside the United States that lasts more than 180 days, about 6 months, without proper advance authorization, can automatically trigger a residency review when you try to come back. In other words, when you arrive at the airport or border, the officer will already see that you've been gone more than 6 months, and the system will flag your record for closer inspection. But the rule doesn't stop with individual trips. The government will now also look at your travel over a rolling 3-year window. They will total how many days you've been physically inside the United States and how many days you've spent outside. If, over those 3 years, you've spent more time outside the country than living in it, you can be pushed into what they call a review or risk category, even if no single trip went over 6 months. Here's a concrete example so you can see how this works. Imagine you go back to your home country 4 times a year, and each time you stay for 2 months. That's 8 months outside and 4 months in the U.S. every year. Over 3 years, that adds up to 24 months abroad and only 12 months in the United States. Under the older, loosely enforced approach, you might have been asked a few extra questions when re-entering, but you often would have been let in without major action. Under this new rule, that kind of pattern, by itself, is enough to trigger a formal residency review.
And the outcome of that review can be serious. Denial of your green card renewal, denial of your citizenship application, or even the start of removal proceedings if the government concludes that you've effectively abandoned your residence. Now, if you truly live in the U.S. full-time, you work here, you file taxes here,
you only travel abroad for normal vacations, short business trips, or brief family visits, then this 6-month and 3-year pattern test usually won't be a problem for you. But if your life is split between countries, or mostly centered abroad with only brief visits to the U.S., you are exactly the type of case this new rule is targeting. At the same time, the government does recognize that there are legitimate reasons why some green card holders have to spend long periods outside the United States. Things like overseas work assignments, serious medical situations in the family, or study programs that require you to be abroad. To address that, the rule updates and expands the idea of a re-entry permit into what is now called Extended Absence Authorization. Think of this as official permission to be away from the U.S. for a significant time without being treated as if you've given up your green card, as long as your reasons are valid and you document them properly. The conditions around this are critical. You must apply for Extended Absence Authorization while you are physically present in the United States before you leave. You cannot file for it from outside the country. The process is designed to be fully online, with typical processing times of around 60 days for most straightforward applications, which means you cannot wait until the last minute. You need to plan your travel and factor that processing time into your schedule. If approved, this authorization can, in certain situations, cover you for up to 2 years of absence. Qualifying reasons usually include official overseas assignments from a U.S.-based employer, full-time enrollment in an academic program that requires you to study abroad, serious medical conditions or caregiving responsibilities involving close family members overseas, and certain types of government or military service. If you know ahead of time that you're going to be away for a long stretch and your reason fits into one of these categories, this authorization becomes a major layer of protection. It's the government's way of saying, "We understand why you're out of the country, and we're not going to treat that as abandonment of your residence." But not everyone who spends a lot of time abroad will have this authorization, and not everyone will fit the official categories. That's where the next core part of this rule comes in: a formal evaluation of your ties to the United States. Instead of simply counting days inside and outside the country, the new system instructs officers and adjudicators to look at the full picture of your life. They use what's called a ties assessment, which gives weight to different signs that you truly live in the U.S. Those signs include whether you maintain your primary home here, not just a mailing address, but an actual place where you live most of the time, whether you are employed by or get most of your income from a U.S. employer or U.S.-based business, whether you file your U.S. tax returns as a resident, which green card holders are generally required to do, whether your spouse and minor children live in the United States, whether your children attend school here, whether you keep active U.S. bank accounts, credit cards, investment accounts, and other financial assets, whether you hold and regularly renew a U.S. driver's license or state ID and keep cars registered and insured here, whether you get regular medical care in the U.S. and carry U.S. health insurance, and whether you are involved in your community, for example, local organizations, religious centers, or other community activities. Taken together, these factors show where your real life is based.
A strong, consistent set of ties to the United States can help protect you even if you travel frequently, because it demonstrates that you still genuinely live here. On the other hand, if your ties are weak, just a token address, a seldom used bank account, no tax filings, and a family who mostly lives abroad, and you also travel heavily, that combination pushes the government toward a conclusion that you've abandoned your residence. On top of this,
the government has upgraded its entry-exit tracking systems. For years, U.S. border systems recorded entries very accurately, but weren't always consistent about tracking departures, especially at certain land borders. Those gaps allowed some people to be abroad far more than they admitted. Under the new system, every time you leave the United States and every time you come back, that information is recorded and matched in real time. The system calculates exactly how many days you've been out of the country, flags long absences, and identifies patterns where most of your time is being spent abroad. When you apply for U.S. citizenship, the officer reviewing your case will be able to pull up a full, computer-generated travel history, not just rely on what you write on the form. When you submit a green card renewal, your presence and travel patterns will be visible within seconds. When you arrive at an airport or land border, the officer will already know how long you've been out and whether this fits into a larger pattern of extended trips. This is why trying to slip through the cracks based on habit or hope is quickly becoming impossible. Now, let's talk about a requirement that applies to every single green card holder, whether you travel a lot or barely travel at all: the annual confirmation of residence. For the first time, permanent residents will have to actively confirm once a year that they are still living in the United States and maintaining their status. This will be done through a short online form. Once this rule is fully in place, you'll get an annual filing window based on your month of birth. If you were born in March, your confirmation is due each March. If you were born in September, it's due each September, and so on. On this form, you'll need to provide your current U.S. address, your employment or income situation, your tax filing status, and a certification that you are maintaining your permanent residence in the United States. You'll also need to upload recent proof that ties you to your address, such as a utility bill, a bank or credit card statement, a lease, a mortgage statement, or a similar document clearly showing your name and that address. The purpose is to create a standard yearly check-in that keeps your record updated and helps identify people who are no longer truly living in the country. If you miss your annual confirmation deadline, your green card will not be canceled instantly, but your status will be put into what's called administrative hold. That means your record is marked as non-compliant. While you're on hold, you're much more likely to be sent to secondary inspection when you arrive at the border. Any citizenship application you file can be delayed or paused, and your green card renewal could be denied or stalled until you resolve the issue. The good news is that clearing an administrative hold is usually straightforward if you act quickly. You submit the overdue confirmation form, pay the required late fee, and give a brief explanation of why you missed the original deadline. If you respond promptly and don't have other serious issues, the hold is typically lifted. But if you ignore it and go a year or more without filing that confirmation, your case will be pushed into a formal residency review, and that's where the stakes become very high. In a residency review, the government is asking one core question: have you really been living in the United States as a permanent resident, or have you abandoned that status? This is not an informal conversation. It's a structured process where the burden is on you to prove that you maintained your residence. You may be required to submit multiple years of tax returns, detailed employment records and pay stubs, lease or mortgage papers and property tax records, several years of utility bills, school records for any children, bank and credit card statements showing regular activity inside the U.S.,
medical and insurance records that reflect regular U.S.-based healthcare, vehicle registrations, proof of driver's license renewals, and other documents that, taken together, show a long-term, continuous life in the United States. You may also be called in for an in-person interview under oath. During that interview, an officer may ask you very specific questions designed to reveal where you actually live, where you sleep most nights, where your spouse and children live, where your clothes and personal belongings are, where you work on a daily basis, where you see your doctor or dentist, how often you are physically at the address you claim, and whether you own or maintain a home outside the United States. The officer will compare your answers to your travel history, your annual confirmations, or lack of them, and all of your documentation. If, after reviewing everything, they decide that you did, in fact, maintain your residence in the U.S., your case is closed, and you keep your status, although you may be warned to limit future absences or keep stronger records. If they decide that you abandoned your residence, your green card can be taken away. Your path to naturalization is cut off unless you start the immigration process all over again, and you can be placed into removal proceedings before an immigration judge. Now let's look at who is most at risk under this new rule. The first group is what we might call split residence green card holders, people who got their green card through family or employment but never truly moved their life to the United States. Their main home, their spouse and kids, and their primary business interests are abroad. They come to the U.S. occasionally, mostly to keep the card active. Under this rule, that pattern is directly in the government's crosshairs. The second group is retirees who lived and worked in America for years, then moved back to their home country to retire, believing that visiting once in a while would keep their green card safe.
With the 6-month threshold, the 3-year pattern review, the annual confirmation, and the ties assessment, that visit once in a while strategy is now very risky. The third group is business owners and executives who run companies with major operations overseas and personally spend long stretches abroad managing those operations. Even if the company is officially based in the U.S., your long absences can make it look like you primarily live outside the country, unless you're extremely careful with documentation and, when appropriate, extended absence authorization. The fourth group is green card holders who spend extended time overseas caring for elderly or seriously ill parents or relatives. These are often the most sympathetic situations. People doing the right thing morally, spending months outside the U.S. out of responsibility and love. But immigration law cares about days on the calendar and evidence in the file, not just intentions. Without planning and strong documentation, repeated long absences for caregiving can still endanger your status. The fifth group is remote workers who, once their jobs went fully online, decided to live abroad long-term while keeping a U.S. job and a green card. They may still be paid in U.S. dollars, have money going into U.S. accounts, and file U.S. taxes, but their physical residence is outside the country. The new rule makes this point very clear. Working remotely for a U.S. employer from another country does not count as maintaining residence in the United States. If you see yourself in any of these categories, this is the time to act. Don't panic, but don't ignore this either. There are several concrete steps you should start taking right away. First, build a strong paper trail of your life in the U.S.
Collect recent and past tax returns, pay stubs, letters from your employer, leases or mortgage documents, utility bills, bank and credit card statements with regular domestic activity, school records,
medical and insurance records, anything that shows you actually live here. Organize these documents by year so that, if questions ever come up, you can quickly present a clear timeline of continuous residence. Second, recreate your travel history as accurately as you can. Use your passports, airline confirmations, old boarding passes, and email records. Make a list of every single trip outside the United States, with exact departure and arrival dates. Count how many days you were abroad on each trip, then total the days per year and over the last 3 years. Compare those numbers to the 6-month single-trip limit and the 3-year pattern rule. If you realize you've been out of the country more than you thought, especially if you've spent more time abroad than inside the U.S., you need to treat this very seriously. Third, if you know that you'll need to be away for an extended period in the future, whether to care for family, fulfill a job assignment, or pursue a study program, apply for extended absence authorization before you leave. Don't assume you can fix this later from overseas. The rule requires you to be physically in the U.S. when you file. Fourth, get ready for the annual confirmation requirement now, even if your first due date is still months away. Decide which type of document you'll use as proof of address. Make sure your name is on key bills and statements. Set reminders on your phone, your calendar, and anywhere else you check regularly tied to your birth month so you don't miss the window. This is a simple step that can prevent unnecessary trouble.
Fifth, if your situation is complicated, heavy travel, a family spread across countries, or long-term remote work abroad, strongly think about consulting an experienced U.S. immigration attorney. A short, focused review of your travel history, your ties, and your documentation can be the difference between staying safely compliant and unintentionally drifting into a high-risk situation. Finally, let's be very clear about this. If you truly live your life in the United States, you work here, your children go to school here, you file your taxes here, your real home and community are here, this rule is not designed to punish you. In many ways, it actually helps you. By sharpening the definition of residence and clearing out green cards that are not being used as intended, the system can reduce backlogs, speed up processing for people who are clearly eligible for citizenship, and protect the value of permanent residence for those who are genuinely building their lives in this country. Your green card is something millions of people around the world still dream of. The chance to live, work, and build a long-term future in the United States. This new rule is the government's way of saying that this status is meant to be used as a real, permanent home, not just a backup plan or a travel convenience. You've now heard the key parts: the 6-month trip limit, the rolling 3-year pattern review, the extended absence authorization, the ties assessment, the upgraded entry-exit tracking, the annual confirmation, and the residency review process. Use this information wisely. Adjust your travel if you need to. Strengthen your ties to the U.S. Keep your records organized, and if you're unsure, get professional legal advice that fits your exact situation. This is U.S. Citizenship and Visa, giving you clear, detailed explanations of real immigration changes so you can protect your status, your family, and your future in America. Green card holders, stop scrolling right now. A brand new 2026 USCIS rule could get your green card revoked, block your U.S. citizenship, or even trigger deportation if you've been traveling too much. Stay with me, because U.S. Citizenship and Visa is breaking it all down. Legally,
Permanent residence has always meant that your primary home is supposed to be in the U.S., but in practice, enforcement of that idea has been inconsistent. That inconsistency is exactly what this new rule is designed to shut down. The government has now put in place a formal system that tightens what it means to maintain your green card, uses new technology to track travel patterns, and adds new reporting requirements that every single permanent resident will have to follow. I'm going to walk you through all of this in detail so that by the end, you'll know if you're clearly safe, clearly at risk, or somewhere in the danger zone without realizing it. Under the old practical approach, many people assumed that as long as no single trip outside the U.S. was longer than 1 year, they were basically okay. Some people pushed that to the limit. Some filed for re-entry permits, and a lot depended on which officer they happened to meet at the airport.